The Supreme Court is the highest court in India. It is the final court of appeal beyond which there is no higher authority to which a dispute can be appealed. The Supreme Court has a maximum of 34 judges. This includes the Chief Justice of India. There is only one Supreme Court in India. Bench in courts are the number of judges who decide over a case. The division bench has 2 or 3 judges, while a constitution bench has 5 or more. Constitution benches usually are set for cases that involve a question of the law. To be a judge in the Supreme Court, the candidate must be an Indian citizen of age less than 65 years. The candidate should have been a judge of one or more high courts for at least 5 years. Or the candidate should have been an advocate in one or more high courts for at least 10 years. Or the person could be a distinguished jurist, in the opinion of the President of India. Take a moment to look at the qualifications of a Supreme Court judge. The President appoints the judges of the Supreme Court. He does this on the advice of the Chief Justice of India. Jurisdiction is the authority to hear a case or dispute. The Supreme Court has jurisdiction over a wide range of cases. These are classified as 1. Original, 2. Appellate, 3. Advisory, 4. Revisory, and 5. Judicial review. When a case or dispute is being heard for the first time in a court of law, it is called original jurisdiction. Normal cases get heard in lower courts of the country. However, there are some types of cases where the original jurisdiction can take place in Supreme Court. The Supreme Court can hear an original jurisdiction case if the dispute is between 2 states, or between the centre, meaning the Government of India, and one or more states, or between the centre and one or more states on one side against one or more states on the other side. Appellate jurisdiction refers to disputes related to constitutional, civil and criminal cases. These are matters that involves important points of law and needs interpretation of the Constitution that require the wisdom of the judges of the Supreme Court. The President may ask for the advice of the court on any matters relating to public importance or on any question of law. This is referred to as advisory jurisdiction. It may be noted that the President need not accept the advice of the court, and the court is not obliged to give the advice sought by the President. It may be noted that the President need not accept the advice of the court, and the court is not obliged to give the advice sought by the President. The Supreme Court can review any judgment or order made by it, with a view to removing any mistake or error that might have crept in the judgment or order. This is the revisory jurisdiction power of the Supreme Court. The Supreme Court has the power to review any law formed by the Union or state legislature, and it has the power to declare it null and void if found necessary to do so. A court of records is a court whose judicial decisions can be cited as judicial precedents before other courts. These decisions cannot be questioned in any court. These decisions are binding upon other courts, and they have the power to punish a person for contempt of court. The Supreme Court is known as the guardian of the Constitution, as it can issue writs for the enforcement of fundamental rights. A writ is a written order from the Supreme Court or High Court that commands constitutional remedies for Indian citizens against the violation of their fundamental rights. There are 5 types of writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto.